Thank you, Seth. All right, good afternoon, everybody. I'm Justin Efris, the Litigation Section Chair, and I am so pleased to present Dustin Thordarson. He is going to be speaking on a very important and I think probably underappreciated topic of keeping and holding the line, keeping firm trial dates. This applies to all practice areas, although Dustin, like myself, we do personal injury, and it's very important in those types of cases. Dustin is from a firm that you probably all have heard of. They probably need no introduction, Brian Panish's firm. And I want to share just a quick anecdote before we jump into this, which is about 20 years ago, I'm in college. I've become friends with some fellows who went to the Brentwood High School, and one of them played football there. And we kept in touch, and we were good buddies. And then I graduated from law school, and I'm talking to my friend Glenn. He says, "Hey, Justin, have you heard of a lawyer named Brian Panish?" And I'm like, I start laughing. I'm like, everybody's heard of Brian Panish. He got the biggest personal injury verdict in the late 90s, almost $5 billion. I mean, everybody knows him. And he starts cracking up too. He's like, he was my high school football coach, and I could never see him as the serious and successful trial lawyer that everybody else sees him as, because as our football coach, he was so down to earth and fun to be around and just a great coach and a great guy. And that has stuck with me. I think one of the reasons for Brian's success is that he is so good at being down to earth and speaking truth, but also building a great team as a coach and as a trial lawyer and as a law firm owner and manager. So I want to introduce Dustin Thordarson, one of the brightest and one of the newest but brightest and greatest members of their team. He's successfully settled or recovered through verdict over $100 million in recoveries for his clients. He works really hard, and he's got a lot of knowledge and experience to share with us. So Dustin, thank you so much for joining us and presenting on this very important topic today.
Thank you, Justin. And I apologize for the tongue twister of our names. That's going to be a fun one throughout the rest of this proceeding. But I appreciate everyone coming out and taking some time to brush up your knowledge on an incredibly important topic that anyone who's involved in civil litigation of any kind, but especially anyone that handles PI cases or PI crossover cases that you have causes of action with remedies in that field, you need to familiarize yourself with a certain code section. But before I get there, I'm going to just go through a little tidbit. I have a little presentation that I put together. I am happy to share this with anyone. I think you all have it, but if you guys need anything that I talk about during the course of this, provided that it is not subject to either a protective order or a confidentiality agreement, I'll share anything. So let's get right to it, okay, guys? Number one, I've been in practice for a little over 11 years, same area, but half of that experience was as a defense attorney where I learned how to try cases. That foundational experience was really helpful for me in understanding how to see issues from both sides. Now, why are trial dates so important? We need to understand why insurance carriers always want to kick the can down the road. And it really is about some concepts that I'm not going to get too deep into right now, because I want to talk about the actual litigation aspect of this and not like the theory behind why insurance carriers make money. But if you're interested in it, do some research and think about what floating income is versus the income that they collect based on premiums, okay? And the money that they keep in the market that's invested is an asset to them that they have to liquidate at certain points if their revenue is not sufficient to cover that in terms of what they collect for underwriting. More on that, but really the bottom line is we all know as litigators that typically any case involving an insurance carrier that's paying for the cost of the defense, they're going to delay as much as they possibly can before they pay out. And they, as someone who used to communicate with adjusters regularly, and we still do, you know that they give a list of things to their defense lawyers that they have to provide them before they can get authority to try and resolve a case, whatever the authority is that you're trying to get for your client, right? So the more they float, the less they pay, the more money they make. And I'm not going to play the video, but understand the financial ramifications of why every single time you are going to be in a case. I don't think I've ever had a case where a defense lawyer has not tried to continue it, okay? So, knowing that one of the primary goals of the defense lawyer is to, at some point in time, in the 6 months to 4 months before the trial, continue it at least once, you need to be prepared to protect your trial date at all costs from day one. And that starts with being prepared and knowing your file. And there is a code section that's called CCP 36, and that governs certain actions and what you have a right to avail yourself of if the litigant that you are representing is over the age of 70, under the age of 14, either has a terminal illness of some sort, or the interests of justice require that the trial be set within 120 days, okay? Now, we all have to understand that when you are approached by a defense attorney to ask you to kick the can down the road, I would say 95% of lawyers out there think, oh man, that is gonna make it so that I can do that other thing. It's gonna be okay. It's the first trial continuance. The client will be fine. But what signal that sends is that you're not serious about trying the case. You're unprepared, and you are hurting your client most of the time, unless there is a legitimate need, if there's a surgery, if there is some personal crisis of your client. There are always extenuating circumstances that dictate not operating by some standard operating procedure. You cannot treat cases like widgets. There are a lot of people that claim that they don't, but then they rely on these metrics and all these numbers to justify ultimately making a decision that is what they want, not what's best for the client. And that is the opposite of how you should be litigating your cases. Any delay to your client's case is going to prejudice them without question. When you shift the dynamic on the defense, when you have the facts to support it, it will immediately change the entire tenor of your case, especially with the backlog that we are all facing, trying to get normal trials out in Superior Court and anywhere in California right now. Now, we know that typically trial dates are what make the world go round. They force people to, in essence, reverse engineer what they need to get done before that deadline. And if you shorten that timeline, that puts the insurance carrier in a very precarious position, assuming that you are prepared to execute in a way that doesn't hurt your client by moving for preference, okay? So, under the Code of Civil Procedure, if a court grants a motion for preference pursuant to CCP 36, according to subsection F, it shall set the matter not more than 120 days from the date of that hearing. And that's really important because you cannot move for preference under this statute and be unprepared to try the case when the time comes to do that, okay? However, if you are prepared to try the case and you have all your ducks in a row and you line everything up from the moment you get the file by way of retaining the appropriate experts, by way of obtaining all the relevant medical records, all the bills, all the films, you get all of that stuff as you're filing your complaint. And the reason why you're doing that is because you should do that on every case, number one. Number two, you also have to have a plan in the back of your head that if you're using this statute as a basis to request that a court preferentially set the trial, you just need to make sure that you are adequately supporting your papers with competent, admissible evidence that satisfies what the court needs. And if you do that, it is a mandatory provision under subsection A and subsection B. But again, keep in mind, continuances are very difficult to come by in this context. At most, you are allowed to move a trial date by up to 14 days, okay? So if you use it, you cannot do this and then find out that you have an expert that you retained and you paid a lot of money that's going to be unavailable. You have to plan ahead in order to make sure that you can properly execute everything when the time comes. And it really changes the dynamic for the defense because the typical defense discovery games that you encounter in a normal litigation context that requires IDCs, motions to compel, ex partes, all of that, there is much less tolerance in my experience that judges have for litigants in this type of a context, given the shortened timeline that it creates, okay? So, why do we want to make sure that we know the age of our clients? Because if a party to a civil action who is over 70 years of age, the court may grant a petition, or the court shall grant it if they find that they have a substantial interest in the action as a whole, and the health of the party is such that a preference is necessary to prevent prejudicing the party's interest in the litigation. And so I want to break this down because anyone who's ever filed a motion like this that has not succeeded, the reason why you failed to succeed is because you did not support your moving papers with the proper evidence that is required. And judges will use that with a skilled defense attorney who knows how to orally argue a case. They will deny your motion without prejudice and make you bring it again until you figure out what it is that you need to do, okay? So, first and foremost, how do you prove that someone is the age that they are? I love using responses to form interrogatories because they're verified responses under penalty of perjury from my client that doesn't create the need to draft a separate declaration. I think it's just streamlined because presumably you're in litigation if you're filing a motion for preference. Hopefully the defense has listened to you when you've told them the moment that they responded to the complaint that you're filing for preference, and you put that in writing so that when they come and oppose your motion and say that it's prejudicial to them, you can then show that they've been on notice of your intention to move from preference from day one. And when you finally get that motion heard, whether it's 1, 2, 3 months out, you have the paper trail already set up from day one, because they're not going to take you seriously when you tell them that you're going to move for preference. You have to show that you're going to do it, and then they're going to pretend like they actually are going to be able to oppose it. And the only real basis to oppose a motion for preference, other than due process, is attacking whether someone has a substantial interest in the outcome of the action as a whole, or whether the health of the party is such that a preference is necessary. Okay? Now, interestingly enough, I've litigated the substantial interest issue in a death case up north, where I represented a widow and a 4-year-old boy and his 14-year-old sister. Their dad was killed in an industrial accident in an oil refinery. And I moved for preference because his son was under the age of 14. And the lawyers that opposed that motion took the approach of trying to attack the fact that the 4-year-old son, who depended on his father as the sole income earner and breadwinner for the family, that he didn't have a substantial interest in the action of a whole, because he and his sister's interest represented 25% each, and the mother's interest represented 50% or more. Therefore, the court should have denied my motion. And obviously the court granted the motion. And in her order, she looked up the definition of substantial in Merriman's dictionary, and then listed that in the order of the court and granting the motion, and basically just totally slammed them for even arguing that, because it is not a discretionary thing. This is, I hate to say it, but it's as close to an equation as you can get. You have to prove 70 years of age, a declaration with a copy of their driver's license, or just, I was born on this date at this time. Bam, okay, we're good on that. How are they going to oppose that? They won't. The party has a substantial interest in the action as a whole. If your client was injured, if your client is in civil litigation because of a breach of contract, whatever, they obviously, being a party to the action, have a substantial interest in the action as a whole, because they filed suit. Then you get to the health of the party is such that a preference is necessary to prevent prejudicing that party's interest in the litigation, okay? Now, it's interesting because the substantial interest, like I said, people try and attack it. But if you are representing someone, I don't think I've ever had a case other than a very large coordinated matter involving slides out in Pismo Beach, where there were over 30 claimants in that action. And that was a close call that the court denied without prejudice. And that's the only time I've ever been unsuccessful in 11 years of litigating this issue. And so one of the things that you need to key in on, that is something that defense lawyers always love to try and point out, is the health element. That does not mean that your client is dying, okay? And this is particularly important for our clients that are the age of 70 or older, right? So typically, defense lawyers will oppose your motion and say that your declaration about your client's medical condition is insufficient for purposes of establishing this element. And there is actual specific case law that says whether or not an attorney can give a conclusory, basically hearsay description of the health condition and it be sufficient for purposes of establishing the health condition element of this code section, okay? So why that's important is you don't have to attach medical records. That's not what's required of you. And you have to be familiar with the legislative history that played a role in enacting this code section, because one of the hardest ways to have a case preferentially set for trial is using subsection E. So notwithstanding any other provision of law, the court may, in its discretion, grant a motion for preference that is supported by a showing that satisfies the court that the interests of justice will be served by granting this preference. So what does that mean? Right? Because do you really want to bring a motion that calls into question the life expectancy of your client, whether it's related to a business transaction or a bodily injury claim or a wrongful death claim? Or, I mean, you don't ever want to send the message that your client is dying, other than, I mean, other than if it's true, obviously. And that's why this statute exists. I once, as a defense lawyer, actually moved for preference on a case back in the day, and I don't know of any other defense lawyer that has. I'm sure they're out there, but typically, when you move under 36E, you are trying to establish by the record that the interests of justice justify granting it and setting the trial within 120 days. And I recently tried moving a court for this relief up in Fresno, and the case involves an individual who was working. He was a sprinkler installer for new home developments, and he was on the job. He was inside of a house getting his tools set up for his day of work. At the same time, there were roofers. There was a crew of 4 roofers on top of that roof. And as he was leaving the inside of the house, it was in the framing stage, returning to his work truck, a roofer takes an unopened 60-pound roll of roofing paper and throws it off the roof, and it struck him in the head and upper torso area. He was diagnosed, he went from the scene home in intense amount of pain. He's transported to Kaiser the next day, diagnosed with a concussion, TBI, and he has not been able to return to work. He's got 5 kids. His wife is not the breadwinner and is the sole provider for all the children. And so what do you do for a client who the court has vacated on its own motion 2 different case management conferences to try and get a trial date for your client who can't earn a living for his family because of the injuries that he sustained, right? You have to get creative. And so I moved under 36E, and I attached all the testimony from every deposition that we took that established that the independent witness saw this guy throw this thing off the roof. All of their employees lied. And the only thing left to do in the case was take damages witnesses and treating doctors. Now, the judge denied my motion because being destitute, basically, unfortunately, is not good cause according to that judge's opinion with respect to setting a trial date within 120 days. But what I did get was a trial date within less than a year. So even though I didn't prevail on the actual battle, the thing that I needed was a trial date, because trial dates, I earnestly believe that courts in California really do their best to keep trial dates firm. And we as plaintiffs lawyers have to keep defense lawyers honest, and we have to follow through when we say we're going to do things. So indigents, for example, we've had clients with amputations who we've moved on that basis, and courts still have not granted the motion in that context. Looking at the legislative history, if you ever need to move to try and get a trial date because a judge has been kicking the can down the road, one way that I would recommend that you beef up your points and authorities is to make a request for judicial notice when you file your moving papers, and you ask the court to take judicial notice of the legislative history behind passing CCP 36, because the more that litigants do this, the more it's going to be in the minds of judges that there really are situations that should be defined as in the interest of justice, requiring the judge to grant that request to set the trial within 120 days. Another thing that I am pushing, that I have going on in 2 other cases of mine, is I have cases where the defendants are over the age of 70. And in those cases, there have been certain things happening in terms of demands that were made, and insurance carriers not responding or accepting to the demands that can have legal implications for the potential recovery as a result. And I think that the logic behind 36A and 36B, for that matter, in terms of giving our most vulnerable in society an opportunity to have their day in court, the logic should apply that you should be able to use the litigant on the opposite side's age as a basis to move for preference, because someone in our context who's catastrophically injured, who has potentially what's called an open policy, has to wait until they get their day in court. And if that person who's over the age of 70, who's a defendant, dies, so does the open policy and the potential to recover for that injured person, despite the fact that they did nothing wrong. And so you got to get creative about how you use these code sections in your practice, and what discovery you do to make sure that you prove up anything that you need to in order to get this set. I have, you'll learn in the context of doing this that you will litigate certain issues that are not as apparent to you that you would think. The substantial interest in the action as a whole in the context of a wrongful death case will give rise to the defendant's ability to attack any one of your clients' standing if there's any issue under the wrongful death statute. I once had a case where I represented a family of 8 people whose, I mean, she was the ship. She was the whole ship. She steered her family from day one. I mean, this was out of an absolute movie. She was run over in a crosswalk, crushed and killed by an unnamed cement truck company. And that woman had 7 children, 5 that she gave birth to, and 2 that she adopted in Laos when her husband was informing for the CIA on the Viet Cong activity in that region. And then ultimately they fled the country, went to 2 different refugee camps, and then she ended up fighting to bring her 7 children over to the United States, where she then raised them as a single mother. One of those 7 children was autistic and developmentally disabled and required 24/7 care, and she took care of her daughter the entire time. Now, there's a standing issue because under the wrongful death statute, if you are a stepchild, there are certain rules and requirements that you have to prove. But what the lawyers defending the case failed to do was any discovery on the standing issue. So I moved for preference, and after the first round of briefing and oral argument, the judge took supplemental briefing on the standing issue and granted the motion. And what turned into a motion for summary judgment on that issue, which we most likely, who knows what would have happened with additional discovery, but that changed that trajectory of that case into an $8 million settlement by virtue of moving for preference and not giving the defense the opportunity to kick the can down the road using the traditional means by which they do to get a trial date continued. So I want everyone to understand that when you do this, you have to have a discovery plan fully set out and ready to execute. And I don't need my PowerPoint presentation for this. This is just me talking to you guys. If you move for preference, you got to be ready to roll with everything. If you do not have experts retained already, you need to have retained experts on every aspect of liability that you need to cover. And you need to make sure that you're serving your discovery 10 days before or 10 days after you effect service of process. You need to serve those PMK notices 20 days after you effect service of process. And you need to give the defense everything that you have, because that nullifies any potential due process argument that says, oh, well, we need our experts to review all the records or review all the documents in whatever file, and it's huge and it's prejudicial and we can't find anyone on short notice to get this done, and so you can't possibly do this. But if you are prepared with all of that up front, what that does is it completely takes the wind out of every argument that they could possibly make in opposing a motion for preference or just generally trying to continue a trial. While I'm preaching this in terms of its application to CCP 36, this is how I litigate every case. And if you do that, you prove to the judge that you're being diligent, and you have to move on this stuff the first time. I actually recently have been very impressed by the informal discovery conference process in pretty much most courts in California. When in the past, especially when the PI Hub was created, trying to get an IDC within a reasonable period of time to resolve any discovery dispute, like just disclosing insurance coverage or disclosing, surveillance footage of an incident that the store has in its possession. They just are choosing not to. Things like that used to take 3 months to resolve. I have had a lot more success lately in doing what I've said in terms of the timeline of how you litigate your case. If you are effectively prepared and you're utilizing technology and your team resources to your advantage, there's no reason now, especially with what we have available to us, to not execute in that manner. You can create things with your team. We all have standard operating procedures, but there is a way to make sure you have to make sure that the age of your client is something that you are aware of and it's on your radar first thing, right? Because as lawyers representing people, typically they hire us in a civil suit because they want money, right? And they don't want their money in 5 or 6 or 7 years. They are clients and we are providing a service. And if we provide that service at the level that everyone is capable of doing just by simply following the rules, and then literally I mean, my IDC statements take me 3 minutes to type. It is a succinct description of the issue. And if you have a judge that's going to read it and understands the law, you're going to get the judge to issue an order and basically force the other side to agree. That's how I've had it on every single case. I have a motion for terminating sanctions right now pending because I did this already once. There were court orders that were violated and now I'm coming back again. So you gotta do this in every single case that you have in litigation, because you owe it to yourself and you owe it to your client to put your best foot forward and to get the best result that you can. And when you have the opportunity to take on a case like this, you should do it, because you get the defense on their heels. And my last war story, before I start to take a little questions, I have a case against, let's say, a big box retailer. One that you might do it yourself and visit, okay, guys? And my client was walking down an aisle. There were 3 doors that were improperly stacked against what are supposed to be bookend fashion doors in a bay on the ground level. And she walks by, and next thing she knows, she comes to. She has got a huge laceration on her forehead, and she doesn't know what happened next. Home Depot did nothing to preserve any of that footage from that aisle, or has not produced it yet. They have also refused to allow us to inspect their surveillance system. They wouldn't produce a PMK, person most knowledgeable or person most qualified. And I moved for preference, and the court granted the motion. And I have been in that court often as a result, but I'm getting court orders for all of these things now that set up a November 18th trial date that isn't going to move. And I have a brain injured client who has the need for immediate attendant care. And I have a 6-hour deposition that has been completed of a person most knowledgeable about security, who had never seen the security system, has never seen the videos, has no idea how many videos are in there, what was kept, why there were 3 doors as opposed to 1 in the incident report. And these are the things I will use in conjunction with the rules of evidence to preclude them from putting forth any testimony or evidence on these issues. So Home Depot knows that they're in trouble. And if you litigate a premises case like this, you know that people are going to say, well, we don't know where it came from. We didn't do anything. We had our sweep sheet at the beginning of the day. So obviously your client was the one that pulled 3 of these doors out that weigh as much as she did when she walked down that aisle. And then we don't know how those 2 got there on the floor, but the one that was propped up was the one that she pulled over on herself. And then after she was knocked out, she then got up and then propped the door back up before she went and reported it to the store. That's the testimony that I have, because I didn't give them the opportunity to conduct the investigation that they should have back when it happened. And certainly now they are looking into it. But you can drastically alter the landscape and not only do better for your clients, but from a business end and a practical sense of needing to produce income, you can guarantee yourself that within 6 months of filing that motion for preference, that case will either be settled or tried to verdict and dispersed, unless there's some type of appellate issue. And with that, I obviously the anecdotes, I like to talk about things that I do because it's applicable to my practice. And if you guys have any questions, by all means, I am more than happy to answer anything. So with that, I'll open it up.
And you're welcome to put it in the chat box, and Justin can review or unmute yourselves, whatever is easiest, but open for questions. Thank you.
I have a question, Dustin. This is great. Thank you so much for doing this. When you have your motion for preference and it's granted, does that then mean that all of the motions to compel and the discovery games that are played, usually by the defense, because we're plaintiffs' lawyers, so that's how we see it, by the defense, those motions are going to then be heard because the court has to keep the trial date that you originally got from the motion for preference?
So from a practical perspective, and obviously every judge is different, but in my experience, when you move for preference, the judge knows, and they admonish you at the motion, at the hearing, if they grant it, they say, look, if it's 36A, you know this is set in stone. It's gonna happen. Same thing, 36B, it's set in stone. So if you've got a minor client who's got a brain injury, last one, I promise. I just started working at the office, and I picked up one of the files and I reviewed it. And our client was 13 years old and his parents were in the car, all three of them brain injuries. But his was the most severe. And there was no dispute that he struck his head on the back of the seat in the course of running into the bus that was involved in the crash. And I wanted to change the dynamic of the case because we didn't really have a solid trial date. And he was turning 14 on December 9th. So, and this is the last practice pointer I will give you guys, and this is one of my tricks up my sleeve, so this is the good stuff. But once you file your motion, the whole thing is you're selling to the court that there is urgency, there is a need for urgency. So if you get a motion date that's set 3 months out, if you're not moving ex parte for an order shortening time to have that motion heard, you're kind of undermining the urgency involved. Obviously, we're not trying to say that our clients are dying. We're trying to say our clients deserve their day in court. And that's the important distinction to make and to focus on in the policy to combat the typical BS defense. You need to prove your health is so bad that there's something going on. No, the case law is so clear that it can be like a 2 to 3 sentence at most, conclusory declaration from the attorney, right? Nowhere else in the code is that a thing that I'm aware of. So once you do that, then you move ex parte for an order shortening time. And if you are technically sound on your ex parte law and motion practice, I get that granted almost always. Because again, it's telling the judge, hey, judge, I'm here. My client qualifies. I know it's mandatory. I know I'm going to win. That's why I'm going to ask you to grant it on an ex parte basis after I filed it. The trick is, once you file it, you then attach it to your ex parte as your first exhibit. And then that's what you serve on the defense. That's it. And that tease everything up, and then you just have to be able to have the bandwidth professionally to follow through on what Justin's question that I'm getting back to now is, you still have to litigate the case, right? So, but the cool thing is that most of the time, judges will just grant things ex parte when they know that people are playing games, because I will say I love Judge Birdsong. He is incredible. He follows the rules and he suffers no fools. And any judge like that, which is I think most judges that I interact with on a regular basis, they're gonna follow the rules as long as you show that you're being diligent on your end and not letting discovery linger for 9 months or 10 months, a year, and then filing a motion to compel and then doing all, like, you got to show that you're diligent. That's how you separate the wheat from the chaff, and that's how you show that your client is catastrophically injured or whatever, such that they really this is why this exists. And with how difficult it is to get trial dates, I don't know about you guys, but I'm seeing courts now starting to unilaterally vacate CMCs and kick them out 3 to 6 months every once in a while, where it's hurting the clients and it's hurting the cases, because the longer the delay, if you get a life care plan, if you get a business analysis, like a valuation done, whatever it is, once the expert does the work, that's a cost that you incur. And that's not a static thing. That's not a static analysis. That has to be updated according to the rules of evidence, unless you want your expert to get torn apart on the stand. So not only does it cause the practical increase in cost, but it also causes the prejudice to the client of the increase in cost, the delay in time, and the susceptibility to, if you're not over-treating, you're under-treating. If you're not mitigating your damages, you're inflating your damages. So, the concepts run the same, and anything you can do to keep your clients' trial dates intact is, I think, ethically and professionally what we should do in every case.
Another question. Thank you. This is great. I love this. So, can you give us a hypothetical example of what an attorney declaration could say for a client who is over 70, but of course you don't want to shorten their life expectancy because they're
And this isn't being recorded, right?
This is being recorded. So
okay.
A hypothetical.
Hypothetically speaking. So hypothetically speaking, I don't know many people over the age of 70 who do not have type 2 diabetes or some type of high blood pressure, hypertension, you name it. If you spend more than 20 or 30 minutes on the phone with your client, there's no way, there's absolutely no way that there is something that you cannot find. And the way that I crafted it in that death case against Louis Brisbois, I'm not subject to any kind of confidentiality because I left the office that I was at when I worked that case up, or it settled like 3 days after. And in that case, Louis Brisbois they completely were not diligent, and I took advantage of it. And I used the declaration from my client, who I said was developmentally disabled. She was autistic, but the standing issue was the real thing, right? And there's case law that I think you wrote an article about, actually, because I remember reading it either before or after, and I was like, oh man, this is awesome, because I totally used it. And it talks about you have the potential to have standing if you rely on the decedent for the necessities of life. And then it goes on to define what the necessities of life are. And so basically, hypothetically, if your client is telling the truth and there was financial support, in my case, my client raised like 60 outdoor free range chickens out in, God, where was it? It was out in Barstow, or like, inland. And when I went out there to make a video with them, they offered, I noticed that there was a bird frying station, and I had just fried my first turkey for Thanksgiving. And so I said to the clients, I was like, do you guys fry birds in there? Do you guys like cook the chickens here? And then she's like, yeah, these are organic free range chickens. And they offered me a leg, and I ate the whole thing because I love chicken. But bottom line is, from that, and when I was dealing with this issue, I was like, wait, she lived off of SSI. She'd take the bus to go get cash. She'd give money to all of her. She was I mean, it's a big Hmong family and huge extended family. She would give them cash. She took care of everyone. She was the one that was there that would just do all the things. She grew vegetables. And so what did I do? I put together a declaration, hypothetically speaking, with things that can't be traced with like an electronic record, really, but are true, and create what would have defeated a motion for summary judgment on that issue by way of her declaration. But to get back to your issue, the question about describing the health condition, I said that she relied on her mother for 24/7 support because she was developmentally disabled and handicapped. And that was it. I've also used, they have comorbidities of type 2 diabetes, hypertension, and have experienced exacerbations of those conditions related to the injuries. And that's sufficient. You're allowed, like the authority is very clear. Oh, let's see here. From Judge Birdsong. Yep. Exactly. And that's exactly what you have to do. You play by the rules. You are an open book. You don't hide anything, right? All the things that I'm talking about with respect to how to litigate a case are with the assumption that you are above board in everything. And that's why people will treat you differently when you litigate cases with them and you have a career where you've done the right thing when no one's looked every time. That's the most important thing.
Excellent. I do have a question. Over the years, once you take on a case with someone who is either over 70 or has young children, are you finding that the opposing counsel is more likely to settle, given the rising cost of going to trial? How has that evolved from when you
Yeah.
first started till now?
So honestly, I noticed that it all starts with who the insurance carrier assigns as panel counsel. That will send a really big message. You know, if you've been in the industry long enough, who you're dealing with and the type of litigators that they are, or the category that they fall into. And so I find that in preference cases, I don't know of a single case that I've had where I filed for preference that hasn't settled for at least 7 or 8 figures. Because I mean, the one that I mentioned earlier about the death of the guy in the oil refinery, I learned more about welding and boilermakers and those trades in 4 months than I ever did. But I took that case on from a colleague who quit without giving notice. And these little kids and the mom were just in a tough spot. And so I reviewed the file, and the OSHA file was incredible. And it was the most thorough OSHA investigation I've ever seen. And so I moved for preference. That was the one where the judge laughed at them when they made the 25% argument. And I took 34 depositions of every person that entered that confined space before he entered and died. And it was on the 34th deposition, right before trial, that I found out that the welding company that was responsible for the leaking TIG rig welding torch tried to cover up the fact that the torch had been leaking in that confined space for hours after the shift change, because they work in 12-hour shifts, and no one communicated to the second shift the issue that had gone on. And so that was what got the case from 8 million to 12.5 million. But when you have that truncated timeline, the defense lawyers or litigants in general know that they face adverse jury instruction potential if they're not complying with and honoring their discovery obligations. Absolutely.
Excellent. Any final thoughts, Justin?
Well, this has been just wonderful. And I think even for those of us who don't do personal injury, but other types of litigation, keeping trial dates is so important if you're on the plaintiff's side. And delaying the trial date, as we've seen, can be very helpful for the defense side. So thank you, Dustin. This has been really a great presentation. And I'm sure if people have questions or want examples, they can follow.
Yeah, you tell me if you guys need exemplars, by all means, I am happy to share. If you want a preference case, you got to be ready for what I'm dealing with for the next 60 days. So
What's the best way for somebody to get in touch with you, Dustin, if they want to?
In the presentation materials, I have my cell. I listed my cell as, because I work technically, I'm remote. When I do go in, I go into the West LA office. All my calls are forwarded to me, so email or cell phone, text me first, probably because I get gazillions of calls, and that way I know who it is, and I will share anything that you need.
Thank you so much.